Surviving probate in Alabama, here's a quick guide. First, step back, breathe, and think before you act. Think about contacting family members. Think about final arrangements, funeral, flowers, things like that. Second, locate documents. Is there a will? Is there a trust? Are you the named decision maker in it? If not, who is? Think about who has a key to the house. Is there anybody that maybe that's going to be a problem for? That's something to think about. And then finally, don't pay any bills until contacting your attorney. What I like to call the later first steps are securing assets. This might be rekeying the locks, to go back to a previous discussion. It might be forwarding the mail to the address of the decision maker so that bills and subscriptions and notices and things like that were going to go to the decedent, go to the decedent's decision maker, personal representative, or trustee. Contact your financial advisor, accountant, or estate lawyer as well. Third, preparing to file the necessary documents to officially get the probate started. This is going to require a few documents on the next of kin or heirs at law, depending on what your state calls it. In Alabama, we call them those two things. And I will tell you from personal experience, the more information you put in the documents to open the estate, the better. If the judge receives a batch of documents and everything is, just really well laid out and thorough, the judge is less likely to require an in-person hearing. He or she might instead say, hey, they put everything on paper. I've got no qualms about this. These guys know what they're doing. We're going to get these letters issued as fast as the law allows us. Next, you're going to have to deal with notifications. Notifications are set by statute, and it's one of the reasons that people often avoid probate court by using a trust or other mechanisms like that. Your next of kin is entitled to notice that the estate is open, that the will is being filed, and possibly even much more, like your home is petitioned to be sold or under contract to be sold or something like that. It is your responsibility as personal representative to make sure these notices happen. That could include tracking people down that we don't know where they're at. It could be certified mail, lots of different provisions that the code allows there. Publication is even one we can use in the right instance. Got to deal with notifications. Next of kin, including creditors. Creditors are entitled to notification. Got to notify them under the code, at least in Alabama. Additionally, Alabama Medicaid has to be notified of an estate being open, and this is a very squirrely thing. It's not hard. It's just I think Alabama is the only state in America that has a law like this. It's not hard. You just got to do it and know where to go. It's online, but you just got to know to do it. The next kind of period is the claims period. That's the time period which Alabama law sets for creditors to come forward and file claims against the estate saying, hey, that deceased person owed me money. That's 6 months in Alabama, which is longer than I would like, which is another reason that many of our clients end up doing some kind of trust to avoid probate court. But probate's not the end of the world, and I need not to imply that it is. The 6-month claims period is just longer than I would like. That's all. After that, you're going to deal with taxes, dispose of assets, tangible personal property, the house, the bank account for things, do an accounting, what goes into the estate, what comes out, and then close it up, cover your rear in doing so. That's a rough guide to surviving probate in Alabama.